lack of transparency that characterized the entire process of the proposed amendment of the Constitution were the greatest impediments. The Constitution, the Elections Act, and the Independent Electoral and Boundaries Commission Act contain broad provisions that can be used to conduct a referendum as long as commitment to adhere to the stipulated principles, values, and statutory dictates is observed. The next issue is whether the civil proceedings can be instituted against a sitting president. This was well covered by my brother, Justice Gatembu. And I'll just say, quote, in a decision, Kenya Human Rights Commission and another versus Attorney General, where I sat with Justice Gatembu and Justice Murgo, the court held, and I quote, in effect, a plain and ordinary interpretation of Article 143(2) would infer that the President's immunity is limited to proceedings instituted during his or her term in office, and two, to anything done or not done in exercise of the President's powers under the Constitution. Put differently, the immunity does not extend to acts or omissions that have resulted in civil proceedings commenced prior to assumption of office of the President, or that were not. Sorry, let me take that again. To anything done or not done in the exercise of the President's powers under the Constitution. Put differently, the immunity does not extend to acts or omissions that have resulted in civil proceedings commenced prior to assumption of the office of the President, or that were not in exercise of the President's powers. I'll skip the rest of the quotation. I have not been persuaded to hold otherwise. The President of Kenya does not enjoy absolute immunity against civil proceedings during the tenure of office, and neither is the President above the law. He is subject to the Constitution. However, no civil proceedings can be instituted against the President during the President's tenure of office if the complaint is based on any act or omission of the President in the exercise of the powers conferred upon the President by the Constitution. If the President, in his or her own private capacity, not in the exercise of the President's constitutional powers, were to do anything against a person's private rights, that person would have liberty to file a civil suit against the President in his personal capacity during the tenure of office of the President. But if the President, in exercise of powers conferred by the Constitution, does or fails to do anything that is alleged to be contrary to the Constitution or statute, civil proceedings can only be instituted against the President when his or her term comes to an end. Going back to the issue number 14, was the appellant, the President, Mr. Uhuru, was the appellant, Mr. Uhuru Kenyatta, afforded a fair hearing? To answer this question, I shall consider whether the appellant was served with the petition number 426/2020 and a hearing notice, and therefore are given an opportunity to be heard. Rules of natural justice require that every person must be accorded a reasonable opportunity to be heard before an adverse decision is made against them. If that is not done, any resultant decision that aggrieves the person is a nullity, as was held in Onyango Olo versus Attorney General. Counsel for the appellant submitted that there was no service of the petition upon their client. The petitioner, Isaac Aluchir, filed an affidavit of service dated 16 January 2021, in which he stated that he electronically served the appellant as it was impossible to effect personal service upon him. The email address he used was cos@president.go.ke. The record of appeal shows that on 21st of January 2021, the trial court directed, and I quote, all petitions in the 7 petitions to serve the petitions on all the other parties by close of business on 22nd January 2021. The Deputy Registrar to facilitate the process where necessary. The respondents, interested parties, and Amishi to file their respondents to the various petitions within 14 days of tomorrow. Then the record, I've looked at what it shows. It kept on showing that the first respondent, who was named in his personal capacity as Mr. Uhuru Kenyatta, was unrepresented. So I proceed and make the conclusion that, but assuming the email address that I have read is the official one of the Office of the President or State House, the petitioner did not demonstrate that it was proper to sue the President in his personal capacity, but purport to effect service upon him through the official email address of the Presidency. In my view, the petitioner should have sought leave to effect substituted service by way of advertisement in the local newspapers if he could not get the personal email address of the President. Considering the kind of orders that were being sought against the appellant and the effects of grant of the same, the trial court ought to have been satisfied that there had been proper service of court process upon the appellant. I find and hold that there was no proof of service of the petition and the hearing notice upon the appellant. The appellant's constitutional right to a fair hearing is guaranteed, and Article 50 of the Constitution was violated in that he was condemned unheard. Consequently, all the orders made against Mr. Uhuru Muico Kenyatta, as named by Mr. Olucher in his personal capacity, cannot stand. I would therefore set aside the declaration made by the High Court that Mr. Uhuru Muico Kenyatta contravened Chapter 6 of the Constitution. Next issue whether were the proceedings against Mr. Uhuru Muico Kenyatta res judicata. I proceed to make the conclusion that, on my part, I cannot fault the findings made by the learned judges. I agree with them that the issue as to whether the President could establish a committee to initiate a change or amendment of the Constitution outside the remit of Articles 255 to 257 of the Constitution had not been raised in the earlier petition. The learned judges were therefore bound to hear and pronounce themselves on that important issue. The next issue is whether the Constitution Amendment Bill 2020 violated Article 43(1)(a) in view of the COVID-19 pandemic. Article 43(1)(a) states as follows, and I quote, "Every person has the right to the highest attainable standard of health, which includes the right to health care services, including reproductive health care." Mr. Omoke argued that the President was in total violation of the Constitution when he authorized or used public funds to initiate and promote the impugned bill amidst the COVID-19 pandemic. His argument was twofold. First, that since the country was and is still engulfed by a pandemic that poses a serious health challenge to all, the state should have prioritized the fight against the spread of COVID-19 virus by allocating sufficient resources rather than engaging in political activities. Secondly, the President and his agents, by organizing or attending what he termed as, I quote, massive super spreader events, including rallies and signature collection to promote the BBI agenda amidst the COVID-19 pandemic crisis, was a violation of Article 43(1)(a). It was also in disregard of the COVID-19 directives and regulations issued by the President himself and the Ministry of Health, banning public gatherings, maintenance of social order, and putting on masks Council added. My conclusion on the matter is that while I agree that holding public rallies that are attended by thousands of people militates against COVID-19 mitigative measures, there was no empirical data or scientific evidence provided to the learned judges to enable them make a determinative finding that the holding of the said events per se amounted to a violation of Article 43(1)(a) of the Constitution. And regarding the amounts that were spent, my conclusion is that I find that there was no sufficient evidence to enable the learned judges reach a finding that the expenditure amounted to a constitutional violation. I will therefore dismiss that ground of the cross appeal. Next issue is whether both or either of the Houses of Parliament were infirmed from considering the Constitution Amendment Bill in view of the Chief Justice's advisory for the dissolution of Parliament. I have found that there were orders that were issued by Justice Korir in several matters. The High Court observed that it was in the public interest not to subject the country to parliamentary elections before exhaustively interrogating the constitutionality of the advisory by the Chief Justice, and that public interest supported the issuance of an order suspending any decision to dissolve Parliament. The amendment bill was tabled before the National Assembly and the Senate on the 4th of March 2021 for the first reading. A vote on the amendment bill was taken in both houses on 6th and the 11th of May 2021, respectively. As at the date of tabling and voting on the amendment bill, the orders issued by the High Court suspending the implementation of the advisory by the Chief Justice were still in force, and there was no indication that the orders had been vacated. Accordingly, none of the Houses of Parliament was informed from considering any of the and or debating the amendment bill, owing to the advisory opinion by the Chief Justice. Next issue is whether the High Court erred in finding that the task force did not create a legitimate expectation on the submission by KNUN that it would be incorporated in the Constitutional Amendment Bill. I've looked at that, and my conclusion is that there is no demonstration. Sorry. In this regard, the fact that the proposals by KNUN were not incorporated in the amendment bill cannot be a basis of invalidating the amendment bill. It was not demonstrated that it was only the proposals by KNUN that were not incorporated in the amendment bill. For these reasons, I would dismiss the appeal by KNUN. Number 20, whether the petitioners had made out a case for disclosure and publication of the steering committee's financial information. I have considered what Mr. Morara said in that cross appeal and come to the conclusion that there is no demonstration at all by Mr. Morara that he requested for any information from the President, Honorable Raila Odinga, and the BBI steering committee regarding the budget and public funds allocated and utilized in promoting the impugned bill. The learned judges cannot therefore be faulted for declining to issue their aforesaid orders. Consequently, I would dismiss Mr. Morara's cross appeal on the issue. And the last one is whether the High Court erred in admitting Amishi Kuria who were partisan. My conclusion is that, in my view, there is no evidence that the Amishi who were admitted to the High Court proceedings were biased. Their respective briefs were of great assistance to the learned judges in determining the issues I have alluded to. Although the Amishi were not parties to the High Court matters, having been admitted in the proceedings in that limited capacity, in the appeals, the first appellant named them as respondents, and therefore they had to file submissions in reply. I must add that I found the submissions quite useful in this appeal. Disposition. Having determined all the issues that we considered germane in these consolidated appeals, the final orders of the court are as follows. A. We uphold the judgment of the High Court to the extent that we affirm the following. 1. The basic structure doctrine is applicable in Kenya. Sichale J.A. dissenting. 2. The basic structure doctrine limits the amendment power set in Articles 255 to 257 of the Constitution. Sichale J.A. dissenting. For you. Yes. Okay. Sorry, I take this back. 2. The basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. Okwengu J.A. and Sichale J.A. dissenting. Number 3. The basic structure of the Constitution can only be altered through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collection of views, constituent assembly debate, and ultimately a referendum. Okwengu, Katembu, and Sichale JJA dissenting. 4. Civil court proceedings can be instituted against the President or a person performing in the functions of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Tuyot J.A. dissenting. 5. The President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 6. The Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report, the BBI Steering Committee has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. 7. The Constitution of Kenya Amendment Bill 2020 is unconstitutional and a usurpation of the people's exercise of sovereign power. 8. The Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the Independent Electoral and Boundaries Commission. Sichale J.A. dissenting. Number 9. The Independent Electoral and Boundaries Commission does not have the requisite quorum for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution. Sichale J.A. dissenting. Number 10, at the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was neither legislation governing the collection, presentation, and verification of signatures, nor an adequate legal regulatory framework to govern the conduct of referenda. Sichale J.A. dissenting. Number 11, county assemblies and parliament cannot, as part of their constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill 2020 initiated through a popular initiative under Article 257 of the Constitution. Number 12, the second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to predetermine the allocation of the proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Sichale J.A. dissenting. Number 13, the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral Boundaries Commission are illegal, null and void, because they were made without quorum and in violation of sections 5, 6, and 11 of the Statutory Instruments Act 2013. Sichale J.A. dissenting. And 15, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257(4) and 5 in respect of the Constitution of Kenya Amendment Bill 2020. B. We hereby set aside the following declarations and orders of the High Court. 1. That President Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 2. That Article 257(10) of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct questions, referendum questions to the people. Nambuye, Okwengu, and Kiage JJA descending. 3. The BBI Steering Committee established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette of 10th January 2020 is an unconstitutional and unlawful entity. And lastly, the cross appeals fail and are hereby dismissed. This being a public interest matter, the parties shall bear their own costs in these appeals and in the High Court. In conclusion, on behalf of the entire bench that heard these unprecedented appeals, I wish to sincerely thank all the parties and their respective advocates for the diligent manner in which they argue these appeals and for the industry that they put in the preparation of all the useful material that was availed to the court. The authorities were so voluminous that time did not permit us to peruse and cite as many as we would have wished to. I found the submissions by all the parties quite concise and well researched, and that is our task of preparing this judgment. I also wish to thank our legal researchers and secretarial staff for their immense help in the preparation of this judgment. And with that, we come to the end. We come to the end of our delivery of the judgment in these consolidated appeals. But there is one other, 307 of 2021. I don't know whether Mr. Charles Kanjama is here. Is Mr. Charles Kanjama here? Or is anyone holding his brief?
Yes, my lord. My name is Moki.
Yes.
I appear together with Mr. Kanjama. Mr. Kanjama appears virtually.
Can I request we have order, please? Unless you have to go, just sit down so that we finish. We want to finalize in the next 10 minutes, if not less. This is the judgment of the court, and it's a short one. The genesis of this appeal is that by an application dated 16th of March 2021, Mr. Charles Kanjama, hereinafter referred to as the appellant, sought to be joined as an interested party in Nairobi High Court petition number E282 of 2020, as consolidated with 7 other constitutional petitions, which sought to challenge various aspects of the Constitution of Kenya Amendment Bill 2020. The learned judges declined to admit the appellant to the proceedings. They stated that they would give their reasons for so declining in their judgment. On 13th of May 2021, the High Court delivered a lengthy judgment in respect of the consolidated petitions, but failed or inadvertently omitted to render the reasons for declining the appellant's application for joinder. On 26th of May 2021, the appellant filed a notice of appeal and subsequently a memorandum of appeal challenging the substantive findings of the High Court. The Independent Electoral and Boundaries Commission, the appellant in civil appeal number E291 of 2021, and the Attorney General, the appellant in civil appeal number E293 of 2021, filed applications seeking to strike out the appellant's notice of appeal dated 26 May 2021, as well as the appellant's memorandum of appeal dated 8th of June 2021. Their main argument was that the appellant, having not been joined as an interested party in the consolidated petitions and having not appealed against the ruling of the High Court, could not raise in his memorandum of appeal issues that he had intended to argue before the High Court. This court, Okwengo, Kiage, and Tuyot JJA, on 28th of June 2021, issued the following orders in respect of the 2 applications. 1, I will not read all those orders. The appellant subsequently filed a memorandum of appeal dated 30th of June 2021, which contains 7 grounds. However, only the following ground was in accordance with the ruling of this court, and it was this: the learned judges erred in law by failing to give reasons in the judgment in declining to admit the appellant in the High Court proceedings pursuant to the application for joinder dated 16th March 2021. When the appeal came out for hearing, the appellant wanted to argue all the 7 grounds of appeal, but the court directed that it could only hear the appellant within the confines of its ruling of 28th of June 2021. Accordingly, it is only the aforesaid ground that was argued. On that ground, the appellant argued that the learned judges erred in law by failing to give reasons in the judgment for declining to admit him in the High Court proceedings. This Court of Appeal this ground of appeal is unassailable. The record of appeal shows that shortly after a hearing the appellant's application, the learned judge stated, and I quote, "After due consideration of the rival arguments by the parties, the application by Kanjama to be enjoined as an interested party to the consolidated petitions is hereby declined. The court will give its reasons in its full judgment." End of quote. It is a requirement that under the civil procedure rules, judgment or ruling should contain a concise statement of the case, the points for determination, the decision, and the reasons for such a decision. The object of this requirement has been explained in several authorities. Although the learned judges had given the appellant the indication that the reasons for their ruling would be given in the judgment in the consolidated petitions, no such reasons were given. Accordingly, we find that the learned judges erred in failing to give reasons for declining to admit the appellant in the High Court proceedings pursuant to his application for joinder dated 16th of March 2021. This is a case where an order remitting the matter to the High Court for the giving of reasons would have been apposite. Given the specific circumstances of this case, however, where the proceedings before the court are spent and the consequential appeals have all been heard and determined, we would be acting in futility. At any rate, no prayer to that effect was made. We say no more. We make no orders as the cause. That is the judgment of the court, signed by all 7 judges here. So with that, ladies and gentlemen, counsel and parties present and those who are following virtually, we've come to the end of our session, but I see Senior Counsel is on his feet. Senior Counsel,
yes, yes. My lords, my ladies, Mr. President, let me on behalf of the counsels, on behalf of the appellant, and probably those on behalf of the respondents, appreciate the laudatory remarks that your lordships and your ladyships have made towards the performance and the prosecution of their respective cases before your lordships and ladyships. But I, for one, in return, would want to appreciate the patience of the court and the decorum we have experienced in this rather long and complicated appeal, if I may put it that way. But at the end of the day, it is only the duty for counsels to present the cases of their respective clans and for the court to make the determination. And for that, we appreciate the judgment and would only hope that we'll be given copies of the judgment, soft and hard copies, and if possibly they could be certified. Thank you, your lordships and your ladyships.
Thank you. You shall certainly be given soft and hard copies of the same. It's fairly late now. You may get them tomorrow is Saturday. Monday is not too late. You'll get them on Monday. They are ready.
With the court's permission,
yes,
just one
Counsel?
word that I do concur with the sentiments of my learned colleague and senior counsel Orengo, and we want to say thank you very much to the court for your patience.
Thank you, Senior Counsel.
May I say something, my lord?
Yes, Senior Counsel, come in.
Yes. My lord, may I sincerely thank you on behalf of my learned friends. It has been hard work many bulky, fat documents had to be read. Lengthy submissions were made. But my lords, we are stand most grateful to you that you have been patient and you have handed to us the best. Nobody has been a winner in this case. I would say the winner has been the Constitutional Court, the Constitution of Kenya, and the rule of law. May I say something that I have observed, my Lord? Permit me, particularly, Your Lordship, the President. I know this court is committed to development of jurisprudence. And during the submissions, I have noticed that each judge has had to write a judgment of his own, of his or her own. My Lord, I got the impression that this develops our jurisprudence very much. There is much to be learned from what my learned Judge Sichale said as a dissenting judge, as to what my learned Judge Justice Okwengu said. We can develop the law, we can develop the jurisprudence of the country if at times we do what you have done in this case, that each judge writes the judgment gives his or her own views on the matter. My lords, it is during crisis that you can see large judicial minds. This case has been a big case, and one thing that I've observed on my own is the greatness of judicial minds we have in the country. As a country, as one of the judges pointed out, we tend to criticize ourselves a lot. And at times we don't identify that which is good among us. When I was in the High Court, I was able to see some of the great judicial minds we have in the country. They are great. In this court, I have been able also to see the judicial minds that we have in the country. Some of the judicial minds, my Lord, if you may permit me to mention some of the things that some of the judicial minds I have noticed, they actually do measure very favorably with the great names that we hear in the West, names like Chief Justice Marshall, names like Chief Justice Kiwanuka of Uganda, names that we have had Lord Chief Justice Lord Justice Atkin, and even the great Constitutional Court judge in Germany. We have great judges in our country, and this is great hope for the country. Great hope in a sense that we shall have the rule of law in the country, and we shall develop our own constitutionalism. On my own, I may disclose that I have received a lot of calls from overseas, people interested to know what is going on. Kenya has scored a mark, that people are seeing that jurisprudence is emerging in this great country of ours, and all of us can be proud of it. My lords, with those few remarks, again I say to you, thank you very much. Nobody has been a winner in this case. This morning, I was really not going to come to this court because I had a personal problem to attend to. But those that I asked for, the Kenya Human Rights Commission telephoned me and said, Kameme, you must go to court. Kituo cha Sheria telephoned me and said, Kameme, you must go to court. And what we want you to tell the court is that if the judgment is delivered against us, we want you to put in a notice of appeal immediately. I'm glad that I will go back and tell them that what happened in the court is that the Constitution of Kenya prevailed. The rule of law in the country prevailed. There has been another very happy development, my lords. I was listening to the former Attorney General Muico talking. He said something that I thought was very impressive. He said that, look, the trouble with this case that we have of BBI is that nobody seems to agree with anybody. There is disagreement everywhere. Indeed, that has been true. We disagreed a lot in the High Court. We disagreed a lot in the Court of Appeal. But what is beautiful is that in the end, my lords, you have been able to bring us together, all of us. When we all leave this court, we shall all be smiling that justice has been done. Their lordships have been able to tell us what the law is. They have been able to interpret the Constitution to us very favorably, and in the future we can be able to refer to it in courts and elsewhere. Above all, there has also been a very happy development. I was reading in the newspaper yesterday, I think it was yesterday, the Right Honorable Prime Minister, Raila Odinga, said was to this effect, that we do not mind very much as what their lordships say. We shall be bound by a judgment. And if we are defeated, we shall proceed and continue with the campaigning. That was a very happy development. I was impressed by that statement that was coming from a statesman. And then our own president, Uhuru Kenyatta, in Mombasa, made a similar statement when he said that he was addressing BBI. And he said was along this, to this effect, that I have done the best I could have done for BBI. Now, much depends on their lordships. If they deliver in our favor, well and good. If they don't, I have done the best I can. My lords, that is the way things should be. The executive, the judiciary, and some of us who are agents of the law, who are advocates, and the ordinary mwananchi who moves in the name of Wanjiko, we should all be committed to the rule of law so that we can all move forward and we shall all be beneficiaries. Thank you very much.
Thank you very much, Senior Counsel. And with those many remarks, we come to the end of this evening, this session. And the court will now rise and wish everybody good evening.
Kameme TV, Muthegi wa Ruriri.
Ngarisha na Optiven, Garden of Joy kuma Optiven ni